The reason I did that is, number one, I sincerely and genuinely think my clients deserve every penny of that. Even if they're not going to get it because of the cap, I firmly believe in my heart of hearts they deserve all of that money. Welcome back, everyone. Craig and Leah here. How are you today, Leah?
I'm all right. How are you, Craig?
I'm still recovering, but doing well.
Yes. What
Yeah.
are you reeling from?
Yeah, last week I was off trying my last medical malpractice jury trial. Hopefully not my last jury trial, but my last medical malpractice jury trial was a week-long trial. Actually, we had planned for up to a week and a half, but it took a week. So I was in Green Bay and finished that. We could talk a little bit about the result here in a minute, but the trial itself is like, the closest I can describe it is like finals week, but like on steroids. And then the lead up to it, like especially like the week before, the 2 weeks before, all you're thinking about is that. And then you're gradually thinking about it in the months leading up to it. So it's one of those things where there's just a strange relief once it's done. You don't have to think about it anymore. So I'm in that recovery. Fortunately, I had Emily helping kind of monitor email traffic and stuff while I was gone, so I didn't come back to a whole bunch of fires. But there's always a certain amount of digging out that happens when you're literally off the radar for a whole week and then some.
So, what was the verdict?
So it was a defense verdict, which means I lost. The jury was out for about an hour, and that is pretty typical when the defense wins these things. A short verdict is never a good verdict for the plaintiff, the person bringing the claim. And each of the cases that I've lost, the medical malpractice cases I lost, it was the same thing. The jury was back within an hour. And we'll talk about that in a little bit. One of the many things about medical malpractice litigation, especially in Wisconsin, that is unfair to the plaintiff and skews in favor of the defense, kind of contributes to that. So we can talk about that in a little bit.
Yeah. So, you want to talk about it now?
Okay, let's talk about it now because otherwise I might forget. So there are, in Wisconsin at least, I have not tried to a jury a malpractice case in any state other than Wisconsin. I've litigated them, but I don't think I've tried one to a jury in any other state.
Want to explain the difference really quick? Litigated, tried, or is it pretty obvious to listeners?
Oh, litigated, it really just means anytime something ends up in a lawsuit, which may or may not include a trial. A lot of times cases get litigated, so they get into the court system, but they settle before trial. Trial is being tried is the actual trial itself. So that's how I distinguish them. So I've had lawsuits regarding medical malpractice in other states, but none of them ended up in a verdict, never went to trial. And in most states, especially in Wisconsin, there are differences in the rules. There's differences that affect the lawsuit from the beginning. There's a lot of rules that are different in the actual trial itself under the, I guess, broad umbrella of tort reform. I would call it tort reform, that are designed to try to take away any advantage the plaintiff might have and to in turn give an advantage to the defense, because they're medical malpractice cases. And I think the underlying theory behind it is, if there aren't some like restraints, some checks, I wouldn't even say checks and balances, but some artificial restraints on the process, that large verdicts in favor of plaintiffs could impact the cost of practicing medicine in the state, cost of insurance, all that kind of stuff. And so that's the rationale given for these measures. Now, whether they actually accomplish that or not, I think is a very different question, but that's sort of the argument given for why these measures have been passed in the past. In respect to, so the one I'm thinking about specifically is, so the way a case progresses is, there's sort of like jury selection is the first part. That's where a group of people come in and they're asked questions to see if they are, let's say, biased or know some of the parties, and to actually seat the jury. That's kind of the first step. And then from there, it's opening statements. Then the plaintiff, so the party bringing the case, presents their side of the case first, presents witnesses, experts, things like that. Once we're done, we rest, and then the case shifts to the defense. Now, this much is the same in pretty much any kind of personal injury case or any kind of lawsuit where there's a jury. The party bringing the action, and criminal cases. So like in criminal cases, the state presents their evidence first, then the defendant, and then it wraps up with a closing argument, and there's a bunch of instructions to the jury. That, for the most part, all stays the same, regardless of medical malpractice or, let's say, a car accident or something like that. But in medical malpractice, there are some very notable changes that I think make it much more difficult for a plaintiff. One of those is after the closing arguments, the jury is sent back with a verdict. And it has certain questions on it. And let's say in a car accident case, the first question might be, was defendant Jones negligent? That'll be question. Were they negligent? Question 2 is often, was there negligence of cause of injury to the plaintiff? And then number 3 is if there is comparative fault. They say there's multiple parties, including maybe the plaintiff who might have fault. Then the question 3 is usually, how do we divide up fault between the defendant and the plaintiff, right? 50-50, 70-30, it has to equal 100. That's comparative fault. And then after that is what are the damages? Pain, suffering, and disability, past medical expenses, past lost wages, future pain and suffering, future medical expenses, future lost wages. And then if the person is married and their spouse brought a consortium claim, which means their relationship with their spouse has been affected by the spouse's injuries, then there's a question for consortium. In your typical personal injury case, the jury will they'll have to answer question 1. They will only answer question 2 on cause, I believe, if they answered yes to question 1. But most importantly, they will answer the damage questions regardless of how they answered the first question. So they could answer the question, no, the defendant wasn't negligent, but still have to determine what the plaintiff's damages are, right? So they have to kind of work out all that stuff. And it forces the defense to, if they want to challenge the fault, they will say, we didn't do anything wrong. But here also is what we think the damages are. If you think we're wrong and we are responsible, here's what we think damages are. In medical malpractice, the jury never answers the damage question unless they first find the doctor at fault. So that has 2 significant impacts on how medical malpractice cases are tried. Number 1, it allows the defense to never really have to answer damages. They'll just say, we don't think you're going to have to answer that because you won't find our doctor at fault. The reason they can get away with that is because of our damage caps, which limit their exposure. And so they honestly don't care what the damage award is because they're going to be limited both by the damage cap and the minimum insurance. Damage cap in Wisconsin is $750,000 for non-economic damages, pain, suffering, and disability. And also they only have to carry $1 million in insurance. So regardless of the result, they know that's the worst case scenario. And so they don't argue damages. In this case, they let someone else, that being the Victim Compensation Fund, which I'll talk about them in a second. But the underlying doctor and their insurance company, lawyers, won't talk about damages. They won't argue damages to the jury, and because they don't have to, and it doesn't matter to them really if the plaintiff wins and they get a big verdict. All they care about is winning. They don't care about the amount if they lose. Well, then what they also do, and they really do this in their closing argument, is, hey, and this is all 3 medical malpractice cases that I've tried that lost ended up on a Friday afternoon every single time. And so the jury is told, hey, it's a Friday afternoon. If you don't want to be here late, just answer no to question number 1 and you can go home. And that's what happens. So it gives them an argument to the jury of, make this easy for yourself. Now, I'm not saying that the outcome would have been different had that not been the case, but it's just one of the rules at the end of a case, and a hard fought case, where it just gives the jury, it just gives them an easy out. It gives them an easy out that benefits the defense. And that's ultimately what happened in this case. The jury was out for an hour, didn't think the doctor was negligent. And so, yeah.
Saves them from doing math before the weekend, I guess.
Yeah. And again, I mean, maybe it doesn't make a difference. But it would be nice to know. And I think it would change the dynamic of the case if the defense was truly required to confront all of the aspects of the case, including damages, and get up there and tell the jury and try to be credible with the jury. What do we think the plaintiff's damages are?
Even if they aren't required to pay those damages, if they lost, that would change.
Yeah. I think if you're required to answer the damage questions, if you're compelled to tell this jury what you think the damages would be, even if we don't think reliable, that puts that party and their lawyer's credibility at stake. So if they go in there and offer say a really small number, then that can challenge their credibility with the jury, and the jury maybe the jury doesn't buy them then on the question of fault and negligence, right? But it gives them a pass. They don't have to put their credibility on the line on damages.
But you had to do that. In the trial prep and just the case in general.
Yeah, and that actually goes to a really important point I wanted to make about this case. Now, at the get-go, I want to say this. We had a really good jury in terms of the jury was very attentive. We had a really good trial judge, which helped. I think the judge gave really fair rulings on some of the fights that come up over evidence in trial. I won some and I lost some.
Nice.
But any of the ones I lost, the judge's reasoning, even if I didn't agree with it, made sense, right? We had a really good judge, and I'll be fair, the lawyers I tried this case against were very professional lawyers. We got along very well, even though we were advocating very different positions. And so that helped a lot. There wasn't a lot of fighting either in front of the jury or away from the jury in this case. As I mentioned to you, so there's two lawyers. I'm up against two lawyers in this case, in these kinds of cases. One is the lawyer that represents the doctor and his employer and the insurance company. As I mentioned before, in Wisconsin, hospitals and doctors only have to carry $1 million in insurance. Well, what happens beyond that? Well, there's this thing. It's called, I think it's the Wisconsin Patients Victim Compensation Fund, and I'm probably butchering it. It's something close to that, although I think it should be renamed because I don't think it doesn't really help patients. It's a protection for doctors, really. So
doctors or medical staff in general?
Doctors, because only doctors and hospitals are real. I mean, I want to say the medical malpractice rules, we call it under Chapter 655 of the Wisconsin statutes, only applies to doctors and hospitals. Maybe it applies to nurses, but I don't think it applies to staff. They fall under the umbrella of the hospital. So they have to carry $1 million in insurance, which what it does is this I think makes sense. I think I understand the reasoning because it says doctors and hospitals, we're going to make you carry $1 million of insurance. And if the plaintiff prevails, that first $1 million is coming from you. It means that you don't have to carry a $20 million insurance policy on all your doctors in the very rare event that a plaintiff wins one of these and gets $20 million. You carry $1 million, and then after that, they pay into this fund. It's kind of like an excess insurance company, but it's not an insurance company. It's actually managed by the court system of Wisconsin. But it's kind of that excess coverage. And then it covers any expenses above and beyond, any award above and beyond that, but subject to the cap, right? The $750,000 cap on non-economic damages severely limits what anyone's going to be able to recover, which is one of the reasons why in Wisconsin, pretty much the only cases that get brought now are what we call bad baby or birth injury cases. And the reason for that is they're the only cases that are going to involve substantial economic losses, future medical expenses. So if you have a baby that's born with birth defects because of negligence, they may require a lifetime of nursing care for the rest of their life, and that can easily get into the millions and millions of dollars. Yes. Those are not subject to the cap. Only pain and suffering. And so that's why, and if there are those cases, then the fund would be responsible for all of that, but only if it's economic losses. In my case, there wasn't substantial. The economic losses we were claiming in the future were about $1.5 million. Right. So anyway, so that's the dynamic. And so the fund lawyer tends to be the one that comes in and kind of handles the damage witnesses, cross-examines our witnesses on damages, hires their own life care planner to counter our life care planner, and makes the arguments in closing argument on damages. But they will always preface everything and say, we don't think the doctor did anything wrong. We don't think you need to answer damage question. But if you do, here's our response to the plaintiff's demands. And again, I tried it against a very good group of lawyers, but I asked for a lot of money in this case. I won't say the amount, but it was in the significant millions of dollars. And after I closed, and while the jury was deliberating, this fund lawyer asked me, so why'd you ask for so much money from this jury when you can only get $750,000? The reason I did that is, number one, I sincerely and genuinely think my clients deserve every penny of that. Even if they're not going to get it because of the cap, I firmly believe in my heart of hearts, they deserve all of that money. Number two, and maybe more importantly, I needed to maintain credibility with this jury. It didn't make sense if I talked about this as a catastrophic injury case, but then if I demand an amount that's way less than the jury is thinking. Because that says, well, do you really believe in your case or not?
I see.
So for me, it's a credibility thing. And then third of all, I think the caps are very unfair. The only one that could really change that is the legislature. Our Supreme Court has already upheld the cap under really extreme circumstances. So I don't think the Supreme Court is ever going to get a chance to reverse that, but the legislature could. And I think it's important. If I had won and initial verdict award was given, I think it's important that they hear what these cases really are worth, so that maybe that can create some traction for revising, increasing the damage cap, or maybe getting rid of it altogether would be my preference. That's why I did that. But it was an interesting question because he's right. On a practical level, I should have just asked for $750,000.
Because that's the most you would have
Right.
gotten.
But I think that would have come across as very uncredible with this jury, and in my own heart of hearts would have been just, I would have felt wrong about that. So anyway, that shows you kind of how this stuff plays out in practice.
Does the plaintiff have any part of it in the trial, like your clients?
Yeah. So my clients were there for some of it. Now, my client cannot get around very well. And I did not have my clients there for the entire trial. I had him there for the first day. And the client that was injured, I called her as a witness. She was my first witness, which is sort of counterintuitive. Typically, you wouldn't do that. But I knew this trial was going to be hard for her, and I thought she would make a positive impact on this jury. So I called her, and also in part because you don't know how long jury selection and openings are going to take. And what the judge doesn't want to do is finish at 2:00 in the afternoon and then send the jury home. So I needed to have a witness available. So I made the decision the day before trial to have her ready, and it worked out okay. So I called her first, and she did great. And in this case, she had what I would describe as catastrophic losses, but I spent a lot of time talking about the hope and positive things that she's done in her life to try to make the most of it. So there wasn't a lot of gloom and doom about this, because one of the things I've learned in studying this stuff is, yes, you have to show the jury the harms, but a lot of that was kind of self-obvious given the nature of this person's injuries. I didn't need to like flesh all that out. But some juries are really uncomfortable awarding money to people. And one of the things that come down to is this money going to help this person? And so I very purposely tried to create in this jury a sense that this person is worth investing in. She's going to take this money and she's going to get the best equipment, the best therapy, all that, so that she can make the most of the remaining life that she has, which was, by the defense argument, cut short by this injury. She's not going to live as long as she would have otherwise. So I tried very hard to focus on the positive stuff, especially with my client, the plaintiffs. I kind of introduced some of the less glamorous stuff through other witnesses, nurses, and things like that that deal with caring for the type of injuries my client had. Yeah.
Any surprises from other witnesses?
A little bit. I mean, no case ever gets tried exactly the way you expect. There's always surprises. We had some scary moments with my expert. I'll just say that. And again, these are doctors. They're not professional witnesses. They are human, right? And no matter how much time, and you don't get as much time as you would like preparing your experts because they're coming in from out of town. Their time is very limited. And so we had a few scary moments with my expert that were probably scarier to me than the jury figured out, because I don't know that it made that much of a difference. So that was something happened on the day 2 with our main witness. Otherwise, no real big surprises. And then, like I said, I finished my case, and then the defense, and my thought is you kind of just try to survive your case and then try to defeat the defense on their case, which is cross-examining their witnesses. And I was very, very, very happy with how I did that. I thought I gave a very effective closing argument, had a couple jurors crying on it. And so I was very pleased with how it went with what I had to work with. I used AI a lot more in this case than I've ever used in any other cases. And in terms of surprises, sometimes witnesses, especially when you're cross-examining the defense witnesses, they'll say something that, like, I don't think that's what they said in their deposition, right? You try to prepare for that. Well, I have what I have, and this is only going to get better with time. Next time I try, my next jury trial is scheduled in June of 2026. It's probably going to look even greater then. But what I had available is I had the depositions for all these witnesses at a time. And when they said something, I'm like, what did this so I'll go in, I'll ask the query, what did this witness say about this? And then cite to the deposition in real time. I did this right during the trial in the courtroom. And it spit out, this is what they said, and here's the deposition cites. And I could decide if I want to pull it up and challenge them with their actual prior testimony. So there were a few surprises. And number one is just being prepared. The biggest thing these cases is just to know your evidence, know your case, and then when things go off script, you can react because you know what what actually the evidence is.
Mhm.
And then having AI there was a nice added cushion. And it really helped me prepare for witnesses the next day.
Yep.
You know, you just, in the evenings, you just don't have time to reread depositions. You say, give me a summary of all the deposition discussion on this topic and this topic and this topic. And then I kind of break my outlines down into topic, and I can pull it out and I can refer to it. So AI really, really helped me in terms of the time saving. Stuff that used to take me 8 hours would take me 15 minutes now. And it was amazing. So that has really helped me in this case. Allowed me to get some sleep.
That's good. That's good. Did the trial judge say anything about AI, or is there any like court rules or anything about using it during trial, or is it kind of just open for use?
No, I mean, technically you're not supposed to be, like, your phones had to be silenced. There, to my knowledge, there's nothing that prevents you from using research during the case. So that's all I was using it for. One thing I will say is this, and I hope this changes, is we're not currently allowed to record trial unless everyone agrees, right? And so what would have made this case even easier and better to try is if I could go into trial with my, this is a recording device, and you can record this and it'll record hours and hours and hours of conversations. And then it will automatically transcribe it, and you can create summaries with it and stuff like that. So I think this is coming, but there will come a time when you can record the trial, and then when you get back to your hotel room, upload it and say, okay, what do we need to work on tomorrow? And it will have that, like, I'm doing my closing argument. I want to make sure I know exactly what this witness said. That's what I think AI is going to make the difference. So right now you're not allowed to do it, and I didn't ask for it, so I didn't try to record any of it, but that would make a huge difference in being able to try your cases. When I was a younger lawyer, the defense would always do things called daily transcripts. You have a court reporter there recording stuff, but they're not actually creating transcripts right away unless you ask them to. So then you're asking the court reporter to do it at night. That was very common, and actually it would have been nice in this case to have that, because then I could take those transcripts and run them through AI at night. But this courthouse, the court reporters wouldn't or couldn't do that unless, so if we wanted day transcripts, we would actually have to hire our own court reporter and bring them in. We didn't do that. If you have access to daily transcripts somehow, either because the court's doing them, or let's say you have permission to use it yourself, that would be a huge game changer, because then you can really effectively prepare for the next witnesses and your closing arguments using actual quotes of what people said during the trial.
So gone is the trial where you have bunches of papers and flipping through and making all that noise like you see in movies.
Oh yeah. I mean, this is the other device I use. This is a Remarkable tablet. It's a digital tablet. And this has been a game changer as I've phased away from paper. I still have to use some, but instead of having a bunch of notebooks, I have that. I can flip back and forth to different screens. And then what I did during the trial, which was new for me, is I had a notepad just taking notes as a witness is questioning. But if there was something I wanted to bring up on my cross-examination or my redirect, I would make those notes here. And then I would just bring this. Then I just had this, because these are the things that I wanted to make sure that I covered. Or like at one point, I might be taking notes and I'm like, oh, this is something I want to use in my closing. Then I had a folder in there with notes that I would have for closing. And so having a digital notebook like this was a really big help in staying organized. And then I take this everywhere I go, and I keep it in my pocket. And in fact, the Sunday before trial, my wife kind of gave me a dirty look. I brought it to church with us, and I had a thought.
Oh my God.
So I'm kind of like trying to be sort of not too obvious, and I wrote over it. I made a note. But I like keeping it with me, because then because you'll be thinking about this all the time. Every waking hour, you're thinking about it like that. So I'm definitely using technology like that as much as I can.
It's better than being on your phone.
Well, that's what I thought. I was like, it was either that or I send myself a message on my phone. So it seemed a little more discreet. So
yeah. We had talked before about focus groups. Was there anything that was really crucial that you got from the focus group that proved itself worthy in the trial, the MedMal trial, or was it not worth it?
Well, yeah. I mean, if there's one thing that I think I want to do more in all of my cases, and it's becoming more affordable now to do focus groups. Focus groups are like mock juries. Like that, you do it, you get a random people, you put out ads on Facebook and Craigslist and all that. if that's still a thing. Yeah. And you'll
That's
have
a
like
domain you can't buy.
right.
Sadly.
No, I wish I had thought of that. You have, like 3 hours and you just ask, you get them talking about your case. We did 3 of them in this case and learned some things. We learned some of the strengths of our case, and we learned some real pitfalls to our case. And we also learned about the type of juror that was best for our case and the ones to stay away from. Now, I will tell you, we knew going in that there was certain categories of people that we thought were not helpful to our case. But then you get there and then you kind of it's a gut call. And I probably made a mistake keeping some people in the jury because my gut told me these people are okay, but based on the focus groups, they probably weren't. But, so you get some information about who do you actually want on your jury, first of all. And then we learned that there was one really big issue in our case that juries would really focus on and kind of disregard the evidence in law. And we were fortunate enough to have the defense move to exclude some of this evidence because they were concerned about it. And it was sort of a gift to us because then it allowed us to argue to keep that evidence entirely away from the jury. Now, you don't know what the jury is actually thinking, but it allowed us to identify one critical issue. So I spent a decent amount of time in voir dire, in jury selection, asking about this issue and if it would be a problem. I thought we got some really good conversations with the jury pool about this issue, that even if they don't end up on your jury, the conversation starts to plant the seeds for things that you carry into the trial. So the focus group definitely helped me identify that and try to frame it as best I could in a positive with the jury in voir dire. But because it was an issue excluded from the jury during the case, I didn't need to deal with it in the trial. But if it had come in, I would have been prepared to how do I try to convert this from a liability to an asset? So and I would have had no idea that the jury would care so much about this had we not done focus groups. So I think it's really hard to try any case, but especially a medical malpractice case or any kind of catastrophic injury case without doing a focus group ahead of time. You get too close to your case and you get too in love with your case and you start to overlook the weaknesses.
Yep.
So focus groups are just a very, very powerful tool that I'm going to be incorporating more and more regularly into all my cases going forward.
The one in June 2026?
Yeah, that case probably has a chance to settle, but if not, I'll definitely be doing focus groups ahead of that one. What I'll probably be doing, one of the things I hope to be doing going forward is to have quarterly focus groups just on my calendar and just budget for that and come in and maybe we'll try 3 different, maybe we'll test issues on multiple cases in front of the same group of people. It doesn't have to be one case, right? What's really nice is to do serial, so multiple focus groups, is you can test an issue and then you refine your case and you come back and test a little better version of that case. So the next one, here's the weaknesses you didn't think about there, and then you go on and do that. So the more you do it, the better you can identify the problems, take them out of your case if you can, and then focus on the positive.
All while using AI.
Using AI. Well, yeah, and when we had these focus groups, we had transcripts. I put all those into AI, and I says, "Give me. I'm going into jury selection. Give me the key points that I need to know in terms of who to be on my jury, things to go over in voir dire." And it was pretty good. It's not a replacement for the lawyer, but it really it may allow you to think about things that maybe you wouldn't have thought about otherwise. I wouldn't have thought about.
Absolutely.
Yeah.
Is there anything else you wanted to tell the viewers what to look forward to? Is there anything else on the horizon for us?
Well, I got a lot coming up. So this was a kind of a bittersweet moment for me. It was my last medical malpractice trial. I've really liked the work and I really enjoy working with the people that I represent, but it's not something I can, for various reasons, continue to do on my own. If people have medical malpractice cases, I'm happy to try to find them lawyers that can handle those cases. And I got some projects in the work that I think people are going to be interested about, but I want to get some pieces in place before I kind of talk about it formally. But I'm not out of the medical malpractice world entirely, but I don't expect that I'll be handling cases in the conventional way. I'll be doing other things that I think will actually make a positive impact on our healthcare industry and on the system in general. So stay tuned for that. And otherwise, my focus now is going to be very much on getting, working to get as good as I can on the farm and truck injury cases.
And our website.
The websites, I'm actually in the process of making an additional website. So just talked to my people about that today. So stay tuned for that. And then AI. So I'm going to South Carolina in 2 weeks for a conference just on AI and the law.
Nice.
So I'm really excited about that. So
You a guest speaker?
no, but I'm going to see if they'll build. Supposedly AI can build a website. So I said, well, here's a website I want built. Can you guys build it? So regardless, that's where the world is going. And like I said, it made a huge difference in my ability to try this case and actually get some sleep at night that I think a lot of lawyers are going to have to adopt. I think AI is a credible threat to the traditional hourly billing lawyer and transactional lawyer. I think people that do estate planning and document generation, I think AI is coming for your job if you don't adapt to it. But for those of us that don't do that way, and saving time is huge, AI is going to be a huge tool
for litigators,
for trial lawyers and litigators. I mean, I'm convinced of that. And that starts not just at trial, that starts from the very beginning of the case when you start building stuff in. So that's the part I'm really trying to incorporate now is what's the right system to have that AI from the very first time I talk to someone up through trial.
Right.
That's kind of the next thing that I'm working on in my practice. So I'm really excited about that.
Yeah. Thanks everybody for listening.
Yeah. If you have any questions or comments about any of that, feel free to leave them below. Otherwise, stay tuned until next time. So thank you, Leah. Thank you, everyone,
Craig.
for listening. And until next time, have a good one.